the early days of this great country, industry, as we came to know it, was in its infancy. People came in droves from all over the world to experience the greatest human experiment in the world's history. They came to populate a land where boundaries to wealth, success, religious pursuits, land ownership, and innovation did not exist. With the explosion of immigration and population came a weary infrastructure that could not, in its embryonic form, keep pace with the rapid growth and expansion of this vast and seemingly endless new land. The founders of the country understood the importance of capitalism to achieve such lofty goals. Old World settlers were eventually awarded contracts from the government that removed any restriction to growth and allowed innovators and entrepreneurs to grow business and industry freely so as to provide the government with the necessary resources and public works to sustain the unprecedented growth of this ambitious new country. As the country struggled through the growing pains of a young child entering puberty, the technology of the day carried the North rapidly forward but left the southern regions of the country in a dusty wasteland where the benefits of true progress had not yet visited. It was becoming increasingly apparent that the old ways of the Old South were inhumane and increasingly obsolete, yet the industry of the North was not finding its way south. The country survived the inevitable civil war that was brought about by the inequality. In time, business from the North began to migrate south to a friendlier climate and a decimated economy screaming for relief. Soon the industrial migration south was followed by a radical increase in the population moving westward. By the late 1880s, industry and commerce were found in all four corners of the blossoming countryside. However, there was one significant growing pain left unattended and becoming increasingly detrimental to the now widely accepted American dream. The old contracts of the original colonies were still in effect, and monopolies began to develop that limited the ability of new entrepreneurs to expand new business and compete with old and more established companies. Soon cries of price fixing and market control on the part of established business gave way to government intervention. In 1890, Congress passed the Sherman Act. While pure in form and intent, the Sherman Act brought with it a new set of growing pains and a learning curve that would continue for decades. The following is an illustration and summary of just one company affected by the Sherman Act shortly after its inception. In one of the earliest cases where the Sherman Act, or the Sherman Hammer as it was called, was implemented, International Harvester became an early guinea pig for the litmus test to define a monopoly. At the turn of the 20th century, the Sherman Act was only about 10 years old. Actual application of the law was in itself still experimental and subject to the whims of certain congressmen and their constituencies. This led to a series of debates both within the lower court as well as the higher court. Kentucky's primary crop was tobacco at this time. For decades prior, International Harvester had manufactured and delivered harvesters to be pulled by teams as opposed to the internal combustion varieties that were beginning to pepper the market. Agriculture was also experiencing some growing pains, and at one point, the whole of agricultural products like corn, wheat, and tobacco was pulled as a commodity in a careless effort to redistribute the take and level the profits for all growers. This, however, did not favor the tobacco growers of the day. At the same time, innovation and the gas and diesel engine were becoming prevalent in harvesting equipment. As a result of this innovation, new parts, different manufacturers, and better trained labor was required to manufacture and maintain the product. While the new product was selling at a higher price, the tobacco prices were falling. As a consequence, the tobacco growers began to accuse International Harvester of price fixing. In 1912, a petition was filed challenging the purchase and merger of several harvester manufacturing companies. The complaint was that International Harvester, in acquiring these other companies and placing them under one corporate umbrella, was able to artificially control and raise the price of the equipment. In 1914, a muddled and questionable decision was handed down from the Kentucky Supreme Court that would lead to a 25-year cat-and-mouse game that would eventually be heard by the U.S. Supreme Court. In the Kentucky case, the Sherman Act was applied applied as a one-size-fits-all solution. This interpretation of the law did not allow for the extenuating circumstances, such as innovation and the ever-changing demands of the agricultural market. It basically forced International Harvester to anticipate increases in not only its own operating and manufacturing expenses, but also the fluctuations in the profit and loss realm of the agricultural business. In other words, if the price of a commodity such as tobacco fell, then the price of the harvester should incrementally be lower to reflect that fall. This calculation was irrespective of the increased cost of materials, parts, and labor, even though these increases were well documented. Restrictions were placed on the sale and purchase of parts, and while the court was never required to enforce the decision, International Harvester agreed to dissolve the merger and sell each model as a separate entity according to the original manufacturer prior to the merger. Other tractor companies existed at that time, but no others were bound by this same decision. In 1927, the U.S. Supreme Court heard the case and found the original judgment in error. In its rudimentary form, the decision revealed that no manufacturer could anticipate fluctuations in the market and as such could not be expected to set a market value price outside of what would have been deemed fair considering all of the costs to manufacture and transport the machine to the respective markets. The decision was long-winded and almost impossible for a layman, and I would submit even an attorney, to decipher. In the end, as it was with the colonies, much of our development as a country and the development of the Sherman Act were subject to error and change. When the growers in Kentucky first challenged International Harvester, the Sherman Act was barely 20 years old and had, by comparison to today's market, very little practical application. The case with International Harvester demonstrated that the AntiTrust law cases needed to be heard on a case-by-case platform that considered all of the information available. Now, nearly 100 years later, we have seen where certain monopolies can actually reduce the price of a good by freeing up the necessary funds for research and development that can further improve efficiency, quality, and inevitably even the pricing. The original Ma Bell, or AT&T, was allowed to function as a monopoly until 1982 before the antitrust legislation was finally enacted against it. This was simply due to the cost of running the lines across the country. It simply was not feasible to have competing companies all clamoring for the right to put up a telephone pole or bury a line in a given neighborhood. By the time Ma Bell was broken up into the baby bells, the majority of the infrastructure was in place. Ironically now, 30 years later, we are right back to having the one AT&T. With respect to International Harvester, the name International Harvester was ruled by the court to be the International Company. Today, International is best known for their commercial truck line. Currently, International builds one of the most popular, affordable, efficient, and widely owned or leased semi-trucks in the world.